Prosecutor hold an ICE agent accountable for their criminal acts? Absolutely, they can, and I'm going to explain it to you step by step. My name's Shannon Locke. I'm board certified in criminal law. I'm running to be the next Bexar County District Attorney, and I practice every day in state and federal court. And I'm going to explain to you how a district attorney at the state level can hold a federal agent criminally accountable for their criminal acts. So ICE agents are tasked with this specific duty. They enforce immigration and customs laws. That's their job. Now, if they step outside of that job and begin committing crimes because they are not tasked with committing crimes, they no longer have federal immunity. So let's say that an ICE agent decides that they're going to engage in these sweeps and just arrest everybody that they see. If they detain people that cannot be detained, if they detain people without reasonable suspicion or probable cause, make arrests without probable cause, then those things are crimes. A prosecutor, if the prosecutor chooses to do so, and that's important, can then investigate those acts. Once the investigation is complete, we can take the case to the grand jury, and the grand jury can decide whether or not to issue an indictment. When an indictment is issued, a warrant for the ICE agent's arrest will also follow. And once the ICE agent is arrested, the federal court, if it chooses to do so, can try to remove the case and say, no, this ICE agent was actually acting within their authority. We're going to remove this to federal court. Now, I practice in federal court every single week. And so I know all the judges over there, meaning that I know how to argue in front of them. I know how to make arguments that they find persuasive, and I would argue why it is that I believed that ICE agent had stepped outside of their duties and made themselves vulnerable to state prosecution. I would do all of those things. Now, my opponents are very clear. They say first that the district attorney doesn't have the authority to investigate things. That's absolutely false. Section 41.109 of the Texas Government Code gives district attorneys the authority to hire investigators, and those investigators have the exact same powers as a county sheriff. You can check it out yourself. Additionally, the supremacy clause. So the federal government can argue that they have immunity, but that argument isn't necessarily persuasive if the federal judiciary finds that the ICE agent wasn't acting within their federal authority. This is an incredibly complex piece of law, and you need to have somebody that is board certified in criminal law and also familiar with both federal and state criminal law practices so that we can execute this effectively and hold ICE agents accountable as they absolutely need to be held accountable.